Hello, welcome to Missouri Law Matters, a podcast all about your Missouri court system. I am your host, Matt Hamner. I'm a judge on the Missouri Court of Appeals in the Southern District of Missouri, based in Springfield. I want to thank you all for being here today and joining us. Don't forget, if you're enjoying our podcast, like and subscribe on our various podcast stations, Apple, Spotify. If you want audio and video, you can check us out on YouTube. Like the podcast, give us some comments, let us know what you like, and maybe even what you want to hear from us in the future. We love getting feedback from folks and appreciate all of the input that we've gotten so far. We've enjoyed this journey, and we are very grateful to those of you out there who are listening, and also to those who are willing to come and hang out and have some of these conversations from time to time. You may know that there are several different kinds of courts that you can encounter in Missouri, and one of the busier courts that we have in our state is our small claims court. Small claims courts are created by statute, and they give people an opportunity to have smaller legal disputes resolved by a judge through a process that is much less formal and less expensive than traditional court. To talk to you about these unique proceedings and to talk a little bit about the judiciary and her experience with us, I have a fabulous guest joining me today. Joining me on today's episode is the Honorable Jeanette Rodecap. Judge Rodecap is currently an Associate Circuit Judge in the 16th Judicial Circuit in Jackson County, Missouri. Judge, welcome to the pod, and thank you for being here.
Thank you very much for having me.
You are so welcome, and I'm very excited to get to talk to you about all of this. We're going to get to the small claims part of this today because I know you have a lot of experience in that area, but one of the things I always like to talk about guests with is their path to the law and their path to becoming a judge. Tell us a little bit about what got you into the law, what inspired you to get into the law, and how you came to be a lawyer.
I grew up on a farm in northeast Iowa, so I really didn't have a lot of exposure to the legal field growing up, but I really enjoyed writing and I enjoyed people's stories. So I went to college originally to be a journalist, but along the way decided that wasn't for me and didn't know what I wanted to do. I graduated with a history degree, thought I might teach, but in between that and going to grad school, I decided to work as a secretary, and I ended up in a law firm in my small town where I grew up. And working in the law firm, I started to see that I didn't really know what lawyers did. I thought they just argued a lot, but seeing them in action, I realized that that might be a way I could use my communication skills and my interest in people to help them solve problems and to help make my community a better place. So I decided to apply for law school and luckily got in, went to the University of Iowa, which was in my home state, and really enjoyed law school. So it ended up being a terrific fit for me. And I wanted to do something where I was working directly with people and getting into the courtroom. So I became a prosecutor as my first career. And I really enjoyed that. And thankfully, it gave me an opportunity to get into the courtroom a lot and get to know a lot of the judges. And many of them were mentors to me. And when some of my fellow coworkers began taking the bench, I started to realize that this might be a good path for me as well. So I began applying, and it is a difficult process. As you know, being on the Court of Appeals, in some counties in Missouri, judges are elected. But in the bigger counties like Jackson County and down in Springfield and in St. Louis, they're appointed by the governor. And so it's a difficult application process, and you need people to advocate for you, write letters for you, fill out a long application. You interview with the commission, and then you interview at the governor's office. And if you're fortunate enough, he appoints you as in the position. And so I was appointed in May of 2014 and took the bench in June. So I've been on the bench now almost 11 years as an associate circuit judge in Jackson County.
That's outstanding. And it's so funny that you talk about your path to the law being something you thought you would be good at because you were a good talker and you like to argue. That is almost the exact same story that I had. It may shock people to know that I like to talk. And my mother always said that I was one of the premier Olympic talkers that she had ever heard. And so I was the same. I wanted to find something that fit my niche and fit those skills that I thought I had. And the law was really a path that it took me on. So that's really fun to hear that other people have had that same experience. Now, as you were coming up after you graduated law school, I know you worked as a judicial clerk in the Western District for a little while, but you also spent some time on a Pacific island. Tell me about that. I don't hear this story every day.
Yes, I did. My first job out of law school was actually working as a federal law clerk here at the Western District, a federal court. But then the federal courts get applications from a lot of the territories of the United States because a lot of the territories are looking for judicial clerks for their own courts. And I stumbled on one for the Supreme Court of Palau. And at the time, this was in the early 2000s, Palau had only been an independent nation for about 10 years, and they had gained their independence from the United States. So they were working to develop their own area of law that was a blend of U.S. federal law with Palauan customary law. And so they were looking for federal law clerks to come to be the experts on U.S. federal law. And then they had tribal elders come in to testify and give background on how property disputes and family disputes would have been resolved traditionally. And we were trying to incorporate the two. The Supreme Court of Palau, there were 4 justices. There still are 4 justices in Palau. One sits as the trial court, and the other 3 are essentially the Court of Appeals, but they're all Supreme Court justices. The entire country is only about 20,000 people, so it is a very small country. When I was there, half of the Supreme Court were native Palauans and half were American. And so it is a real blend of the two cultures. There are 3 court counsels hired every year for a 1-year term, and we would sit in on all of the appellate arguments. We would write draft opinions and decisions of the court. And then we also would headnote the decisions and try to put them into the Palauan reporters. So we were trying to build a body of Palauan case law. And then also one of my duties was to try to go through the rules of criminal procedure and rewrite them more in a Palauan context. So it was a really interesting, challenging legal assignment, but it was also a fantastic personal assignment because obviously I was an outsider in a country. It was interesting and it forced me outside of my comfort zone, and being so far from home to you're just completely outside of anything that you're comfortable with. So it was a great experience. And in fact, I just took my family back to Palau over Christmas this year for the first time in 20 years to see it again, because it was such a formative experience and so important to me in my life.
That's so fascinating. And I have to believe that that would have been really personally gratifying too, to not just do the legal work, but to be in on the ground floor of building something entirely. In Missouri, our case law has been around since the 1800s. We've been building case law for over 100 years. We have our guardrails set, but to be in on the ground floor creating those guardrails, that's really fascinating and really interesting. Tell me one thing that you can think of that was unique to Palau, unique to their law, that you think that we could learn a little something from in our courts as to how we do things.
I want to mention is one of the cases that I worked on was drawing a state boundary between 2 new states. And we looked back at how Connecticut and Massachusetts had determined how they were going to draw their state boundaries back in the late 1700s. So we were looking back at formative case law from the very beginning of the United States to try to figure out how they'd wrestled with some of these same issues. So that was fascinating. One thing that's extremely different from the United States is that their family structure is based on clans, not so much the nuclear family. And it's a matrilineal society. So how property is passed on is very, very different from the United States. And it's often a decision made by the clan as a whole, which are a group of loosely related individuals. The children and the money and so on is passed through the mother's side. So the mother's side is much stronger in the clan, but the tribal elders tend to be men. So we were listening to testimony from the men to try to determine how the property should be moved through the matrilineal line. So that was something that was very different from what we experience here in the United States. That's one example.
So neat. And what a wonderful experience, and a great example of how unique everyone's path is to the law and then ultimately to the bench. There is no one story. It's kind of like a golf swing. There's a million ways to do it. That is just a fascinating journey, and I'm sure very rewarding. Did your family enjoy getting to see this place that was so kind of influential to you?
Yes, very, very much. I took my kids and they'd never experienced something like that before. And fortunately, we're still in touch with people from when we'd been there. We were able to meet up with one of my coworkers at the court who gave us a tour of the island and was able to give us some insights. And that was just amazing. It was terrific.
So wonderful. Well, Judge, you mentioned that you were appointed in Jackson County as an associate circuit judge back in 2014. I think May is going to be your anniversary, right? 11 years on the bench in May as an associate circuit judge. Talk a little bit about all of the various kinds of cases that you have handled while you've been an associate circuit judge over the last 11 years. I am a former associate circuit judge myself, so I have an understanding a little bit of what you do, but those that are listening at home, they may not know. So tell us a little bit about what does an associate circuit judge do for Jackson County?
Well, judges are really generalists. We get a little bit of everything. My background was in criminal law, so at times I do have a criminal assignment, but Right now, I'm on a civil and domestic assignment. So in my domestic assignment, I do dissolutions of marriage, child custody, paternity cases, name changes. And then in my civil docket, I do general civil cases, which is when two people are suing each other over money. So it could be a car crash, a breach of contract, work that wasn't performed correctly. I also do collections cases if somebody owes a debt that they cannot repay of some kind, a credit card, a car loan, a student loan. I also do obviously small claims cases, which we're going to talk about today. I do have a probation violation docket. And then the dockets that I've been working on today are landlord tenant dockets, where we're working on cases where people are facing evictions. So those are my main dockets that I handle at this point.
And what a variety of stuff. That is really interesting. And how do you find the challenge of having all those different types of cases? And I know as a judge, but those listening may not know that all of those various types of cases that you've described have different rules and may have different procedures in some of those cases. And sometimes they even have their own terminology. So how do you find it being able to switch hats and say, well, today I'm doing this, and it may go minute by minute. Like 1 minute you're handling a domestic case and the next minute you're handling a collection matter. How do you find the challenge of being able to switch the hats and do the various things all at once?
Well, thankfully, our dockets follow the same pattern pretty much every week. There is some variety, but you do the same types of dockets week after week. So you do get up to speed on them pretty quickly. It can be difficult to change hats, but luckily I've been on the bench now for a few years. And so it does get easier with time. And I think it's a two-part learning curve when you become a judge. There's learning the different types of law that you're going to be applying, but there's also the learning how to be a judge. And so that part gets a little bit easier as you've been on the bench a little bit longer because you become a little bit more comfortable and confident in that role. And then honestly, if I find myself completely at a loss or where I'm confronting some issue that I've never seen before, being a judge is a nice place to be because I'm not quite so reactive. I can take it under advisement. I can do some research and some extra digging if I need to. I can also ask the parties if needed to brief the issue or to supply a case on the issue. So if I really am unsure of what the law is or how it needs to be applied, I can take a break and take a deeper, longer look at it. So that's a great position to be in as a judge.
Yes, excellent. And certainly would echo that. I've heard from folks who complain about sometimes how long cases take and how long the process takes. And my response to them is always the same. Well, do you want a fast answer or do you want the right answer? And that is a perfect encapsulation of that. And that sometimes when a judge takes a break or takes a breath and doesn't rule on something and doesn't give you a quick decision, that's not a bad thing. That's mainly just a sign that that judge is really considering and taking very seriously what it is you're asking them to do. And the fact that they're taking a little time to do it is a good thing because that means they're really looking at it. Now, you mentioned that you handle some small claims cases and that you have a small claims docket that you're doing now. Talk to us a little bit about what part of your week is taken up by handling small claims cases.
I have a small claims docket on the second and fourth Wednesday of every month. So it is just 2 times a month, but they are very time intensive cases because they typically involve pro se or self-represented litigants on both sides. And the litigants don't have any legal training. And so they may find it difficult to communicate to me as the court as to what they're seeking exactly and why they're seeking it. We do have small claims petitions that are available statewide and on their Jackson County website, but there's a blank where you can write a paragraph as to what you're seeking. So sometimes it's hard for me to decipher in advance what kind of a case I'm really going to be hearing. And often I don't know until the parties are in front of me and presenting the case. So what I will typically do is set the cases for a first setting. And if both parties are present and ready to go, we go ahead and try it that day. But more often we end up continuing it to another docket, and then I'll especially set it for trial so both parties know that they need to be there and be ready for trial on that day with their exhibits and witnesses. And then I give those cases a little bit more time than the regular just small claims docket because I know that I'm going to have to be listening to evidence and witnesses and have people put on exhibits.
But it sounds like it's typical for your dockets anyway, that if you have a small claims matter pending in front of you, it could be tried on that first appearance, but it very likely will be tried by that second appearance. Is that right?
Yes, it will be tried very quickly. Under of the rules, there is no right to discovery in a small claims case. And typically there's not a lot of discovery to be had, even if they did have the right to discovery, because the amounts in dispute are $5,000 or less. So they are not large disputes. And typically the parties know each other already. It's a loan that didn't get repaid, or a neighbor's tree fell on the other person's car, or their dog bit them, or a contractor didn't do good work. So they've got a pre-existing relationship. So it doesn't tend to be something where there would be a lot of discovery or investigation. The case is ready to be tried virtually immediately.
Excellent. Now, you talked a little bit kind of about the process of how a small claims case work. And as an associate circuit judge myself who used to handle small claims cases, I kind of know how that works. But you mentioned a petition. You mentioned that there are forms available on the websites. So if somebody is out there and they wanted to file a small claims case, what is kind of the steps that would be taken to kind of do that?
Well, they would need to fill out the petition, and they'll need to know the defendant's address so that they can be served. They also, in most cases, need to pay a small filing fee, although they could apply for what we call informa pauperis, meaning that they do not have the ability to pay, and the fees would be waived at that point. So they would need to typically come down to the courthouse, to the records department, and file the petition, pay the filing fee, and provide the information for the defendant to be served. The defendant can be served either personally served or by mail in small claims cases, but they need to have a good address and location where the defendant can be served, because if they are not properly served before that first setting, I can't go forward and consider the merits of the case. I need to continue the case to allow the case to be served first, which is only fair when you think about it, because if you were being sued, you would want to know what you were being sued for and when your court date would be. And so that's the reason for service and why we require it before we can go forward and hear the merits of the case.
And certainly service is always a big issue in small claims cases, just because I think it's the part of the process that's most foreign to people who are not familiar with the legal system, that you have to either mail it to them or you have to have somebody actually take the paperwork out and give it to them so that the court knows, as you just said, that this person knows that they're the subject of a lawsuit and that you might take action against them unless they do something. So once that petition is filed, once they get service on the other party, they're going to show up in your court, and they're going to want to potentially, if they can't get it resolved otherwise, they're going to want to potentially have a trial. Now, the statutes talk about that the proceedings in a small claims case are generally very informal, and they don't give us a lot of guidance as to exactly how a small claims proceeding should go. And my experience has been that there's a lot of different judges that do small claims proceedings a little bit differently. How did you arrive at the process that you use for actually hearing a small claims case, and how do you think that that's really benefited you?
I mean, it seems to be what works best in most cases is that I will call the case, and then I do particularly some preliminary questioning just to make sure that I've got jurisdiction and venue, because there needs to be enough contacts with Jackson County for me to hear the case. Kansas City spans 6 counties and 2 states. And so sometimes people will file a lawsuit in Jackson County, but the event took place in Kansas, or it took place north of the river in Clay County. That's hard for people to understand, that where they file it makes a difference. So they need to be filing it where the event occurred or where the defendant is located or can be found. So that's an initial thing that I need to figure out, is whether they filed it in the right place. It's also important to determine if they filed against the right defendant, because sometimes if they're suing a corporation or a company, they don't have the correct name of the company or a corporation or anybody sued that has anything to do with the company. So there are some preliminary things that I'm trying to get through to figure out whether the case really should be in front of me at all. So I'm asking them to state their names. I'm asking them where they reside. I'm asking them when it happened and where it happened. And then I basically ask them a very open-ended question to just tell me why you filed your petition. And a lot of litigants don't really know what is important in the case or what the elements of the case are. And so I often get a long narrative, much of which is not relevant to my decision, but I can question and drill down on things that I think might be important to the decision. And one thing that a lot of litigants forget is that they do need to establish that they've been damaged in some monetary amount, because a lot of small claims cases are filed out of anger or frustration, but you can't seek punitive damages or emotional distress in a small claims case. You need to prove that you've actually suffered specific monetary damage. You also can't sue just to make that person give me my stuff back. That would be equitable relief, and I can't give that either. So trying to get down to what are the actual monetary damages that I can award is also a big issue in many small claims cases.
And making sure, of course, that the damages that they're seeking are within your limit, that they have to be under $5,000. If they want more than that, they've got to go someplace else.
Yes, that's very true too. And explaining to them that they're either waiving anything or giving up any amount of money over $5,000. We're just limited to the $5,000, or giving them the option they could dismiss and refile their case if it's more appropriately filed in some other docket or in some other way.
Now, in your experience in handling small claims cases, is it generally pro se parties? How many lawyers are you seeing in small claims cases? How often does that happen?
Very seldom, maybe 1 in every 10 cases. Most cases are only self-represented litigants with no attorneys at all.
And certainly that's what the process was designed to be. It's not that we don't welcome lawyers in small claims court. It's just the lawyers sometimes don't understand that all the rules that they learned in law school and all that stuff doesn't apply in small claims court. It's just kind of, you tell me what you said, you tell me what he said.
If a lawyer's not accustomed to small claims court, I get a lot of objections. And I do have to remind them that the rules of evidence do not apply, because it's more of an open forum for parties without a legal education to be able to explain what it is they're seeking and why, and for me to make a decision. So it can be really uncomfortable for attorneys to appear in small claims cases.
Now, if somebody has appeared in your court and they come in and they present their side and the other side presents their side, at some point, do you usually issue a decision in your small claims cases right then and there, or do you sometimes take them under advisement, or does it just vary on the case?
Almost always make a decision right then and there. In order to prepare my docket, my law clerk and I make 2 judgments for every case, one for plaintiff and one for defendant. And it's a very short judgment, and it has a blank for filling in a monetary amount. And then it has a second page explaining how to file a trial de novo, which if they're unhappy with my decision, they have the right to file an application for a new trial, which is what trial de novo means. So I have those prepared in advance, and then I will listen to the evidence and the witnesses. And what I often will do is take a brief recess and go back into chambers to finish whichever judgment I decide I'm going to enter. And then I come out and hand it to them right then and there. My thinking being that, number one, they came down wanting a decision. They want a resolution. And so I want to give that to them as quickly as I can. And second, I don't want them to have to wait for the mailing and not know when they're going to get it and not know when the trial de novo period is going to run, because they only have 10 days after the judgment is rendered for them to go ahead and appeal it if they'd like to. So I'd like them to know right away what the decision is going to be. There are times when it is a more complicated case and I do need to take it under advisement for a longer period of time. But as I said earlier, small claims cases don't tend to be terribly complex. And so typically the decision will rely a lot on the facts and the evidence that I've heard and my credibility to judgments. And I can do those on the day of and get that decision to them very quickly.
Excellent. And I'm so glad you mentioned the trial de novo, because I was going to ask you about that. That if someone is not happy with the decision that they get in the small claims court, as you said, they have 10 days from the date that they receive the judgment to ask for what they call a trial de novo. Now, that is not a second small claims case. I got that question all the time. Well, is that just another small claims? I'm going to come in and explain it, and I have to tell them all the same no. For those that aren't familiar, tell us a little bit about, if they're not happy with that small claims judgment, what does that trial de novo process look like?
If they do decide to file for trial de novo, it is assigned to a circuit judge, and the rules of evidence do apply. So it is a much more formal proceeding. They can even ask for a jury trial. The rules of discovery could apply. So it is a much more formal proceeding, and it may benefit them at that point to get an attorney, because it is not as informal and relaxed as small claims dockets are in the Associate Circuit Court.
It certainly is. It becomes at that point like a real trial. If you appeal a small claims, you then get put into the normal system where you have the objections, you have the testimony, you have all of the things that you see on TV and hear in the movies. All that stuff then comes into play. The one thing that I did want to mention that I know I get this question all the time, and I'm sure you've had this too. Small claims court is the only place that if you have an LLC or you have a company or a business, small claims court is the only place you can represent that business yourself. You can walk in and be part of it. If a trial de novo gets filed and you get kicked up to circuit court or to another judge, at that point, if you have a company, an LLC or an incorporated or whatever it is, you will have to have a lawyer to represent you.
I'm glad you mentioned that. We do often have companies and LLCs represented by an owner or an authorized agent in small claims court. But if you do file a trial de novo, you must hire an attorney. You cannot represent yourself in circuit court.
Excellent practice tip. I appreciate that, Judge. Since you have been doing this since 2014, and I know you've probably been handling lots of different types of cases and not just small claims since then, I'm guessing you've undoubtedly seen a lot of changes in small claims court and in the small claims process and how the cases proceed and how they work. What are some of the biggest changes that you've seen in the small claims court since you came on the bench in 2014?
Out of all the areas I handle, small claims may have changed the least. Landlord tenant seems to change every year. There are different requirements in lots of different areas, but small claims hasn't changed a great deal. We did, obviously, during COVID, open up more remote hearings, and we still do allow people to appear remotely at that first docket, but I do require, if at all possible, that they need to be here in person for their trial setting. And the reason for that is that if someone is appearing virtually, particularly if they're a self-represented or pro se, it's going to be difficult for them to present their exhibits in a way that is especially helpful to them. It's going to be hard for them to show their exhibits to the opposing party. We require them to provide all exhibits in advance, but getting them organized and labeled can be very difficult. It can be difficult in person too, but at least we have staff that can help them and walk them through that process, whereas online we cannot. If somebody appears by WebEx, it can be very difficult for them to hear everything that's going on in the courtroom, even if people are speaking up and speaking close to a microphone. And it can be very difficult for them to have an opportunity to question other people if they want to, or call their own witnesses. So I do require in-person appearances for small claims trials. And most people appear in person now anyway, even for their first appearances in small claims.
Certainly, technology is probably the biggest piece of it with online case filings and now access to CaseNet for the public. We've got, forms that are now available, the internet available for research. And now we have the potential use of AI that could be coming down the pipe that people may start using or utilizing. Are those technologies and are those things that you see maybe changing a little bit the way small claims court functions, or maybe improving the quality of the cases that get presented in small claims court?
Just recently attended judicial training where I became aware of a tool that they're using in St. Louis that's a virtual kiosk that you essentially you input information and it generates a small claims petition for you, which I think something like that could be helpful to self-represented litigants and also take some of the burden off of our records and filing clerks who are interacting with pro se litigants, because it's frustrating on both sides, because pro se litigants aren't comfortable with how the legal system works and what the procedure is and what's required, but the clerks and our staff are instructed not to give legal advice. So we need to provide access to the courtroom, but we can't help so much that we're providing legal advice or telling them what to do. And that's a really hard line to draw. And that's something I think that Associate Circuit struggles with a great deal, because we have so many pro se litigants, and it is very frustrating for them because they feel that we know the answers and we just won't tell them. And so that friction maybe could be reduced a little bit if we had better AI tools or an electronic kiosk like I'm talking about that would walk them through the process of filling out a petition instead of them having to ask potentially for legal advice from the clerks.
The development of those automated tools is ongoing. I believe actually your Kansas City municipal courts have also just installed some new AI. I don't know that they're necessarily AI powered, as I put in quotation marks for those watching us on video, AI powered kiosks, but they're creating these virtual kiosks in the Kansas City Municipal Court to be the same function, to help people with filings in their cases and to find information about their cases. I think that the more and more we go forward with these issues of small claims, while the procedure itself may not change a lot, I think that the tools surrounding it are going to change a lot. And as judges, we're going to have to adapt to it And as the public who are seeking those matters, I think they're going to find all sorts of new and wonderful ways to use those tools to present their cases to us. And it's kind of exciting. Now, Judge, when you're hearing cases like small claims cases, somebody generally has to win and somebody has to lose. Sometimes there's ways that you can give both sides something, but usually you're picking a winner and you're picking a loser. And so one side is not going to be happy with the decision that you make. Knowing that going in, how do you balance that? I mean, what can you do to make sure that the people who aren't successful in front of you, even though they put on their case, how do you make them feel like that they've gotten a fair shake and had their day in court?
I give a roadmap to them before we get started. And I explain to them that they need to mark their exhibits, show their exhibits to the other side before they show anything to me so that they have an opportunity to object. And most importantly, I explain to both of them that they will have an opportunity to talk. I just don't want them interrupting or talking over each other, but they will each get an opportunity to tell me their side. And then I listen. And so I give them that opportunity. And like I said, when I set a case, especially for trial, I make sure I have a little extra time because I know I'm going to need time to listen to both sides. I do often take that brief recess to go back into chambers to take one more look at all of their evidence. And then when I come out and I present them with the judgment, my judgment is very short. It doesn't have a lot of detail, but I take time to explain my reasoning and why I thought that was the correct decision and what evidence I found particularly compelling that led me to that decision so that hopefully, even if they don't agree with the decision, they can understand why I reached it.
And that's excellent. I find that your process and your explanation there is spot on because we have a set of rules that we have to follow. We have to follow the law, and we're making those decisions based on that law. And that doesn't make everybody happy. But what I find is those judges who, like you, are clear in their communication, who aren't afraid to tell people, look, I listened and here's my decision and here's how I got there. And if you can explain it to people in terms they understand, and if you can support the decision that you made with the evidence that you've been presented, regardless of whether or not they're happy with the outcome, they can at least feel like that they were heard, that somebody actually at least listened to them. And even though the outcome didn't come out the way they wanted it to, I think that people are often at least respectful of the fact that they were able to say what they wanted to say.
Yes, I think that in my experience, it does seem to help. You are still going to have litigants that are upset because some small claims cases are very personal to people. They're very personally invested and very emotionally invested in the case. And this might be a dispute that's been ongoing for some time. And so even though you're giving them a decision, they may not be able to be done with it yet. And it can also be frustrating for the winning party because I have had situations where I've awarded a monetary judgment for $2,000 and they've turned to me and said, well, where's my money? As if I'm going to also hand them a check. So it can be frustrating because they still have to collect on that judgment. And if the defendant refuses to pay or they're unable to engage in garnishment or collections proceedings, or they don't understand how to do that. To them, it's just a piece of paper, that judgment. It's useless to them. So we really require the litigants in front of us and the community as a whole to respect our judgments and our decision and to follow them, which I think is a danger for the judiciary going forward. And we've seen it. Sometimes people are not willing to follow the decisions of judges. So that's a reason that I am a big advocate of civic education and also podcasts and programs like this so that the general public can understand a little bit better how judges do our job and how we make our decisions so that hopefully they are more willing to respect and follow the decisions if they do have a case that they're litigating.
One of the main reasons I wanted to start this podcast is to give people an opportunity to hear straight from the people on the bench how it is this process works and how these decisions gets made, and to take some of the mystery away from that. Because without us stepping into the void and explaining to people how the system works, there's the potential that they could believe whatever somebody puts out there about how this works. And believe it or not, the judges that you have sitting on your local benches and courthouses in your county or in appellate courthouses in your district, they are people just like you. They are not perfect. They have flaws, but they are all doing the same thing that you are doing, which is trying their best every single day to do their job the way they're supposed to follow the law and to serve the people that we are elected to serve or appointed to serve. And we're very grateful to do that. And any efforts we can make to make people feel better about that process, I think are very good things. So I appreciate you saying all of that. That's wonderful. We talked a lot about all sorts of wonderful tips about things that they can look for and things that they should or shouldn't do in their small claims proceeding if they have one. Is there anything else that we haven't talked about? Any other tips or advice that you would give to small claims litigants who are coming in, who may not be familiar with the process, something that can help them either present their case more effectively, or just things that will keep them from making, I guess, a faux pas?
It'd be good to familiarize yourself a little bit with the rules that apply to small claims so that you come in with an understanding that you do need to get service. Your damages are going to be capped at $5,000, and you do need to be prepared to present your own case. I've had many cases where somebody just hands me a big bag of receipts or a big bag of documents that are in no particular order, or 100 pictures. If you can think through in advance how to organize your exhibits or organize your testimony so that it helps the judge understand your case and reach the decision that you want them to reach. If you're seeking damage to a bunch of personal property, be ready with being able to document what the value of each item was and have that organized so that it's easier for me to understand your exhibits and your testimony. That would be very, very helpful to me.
That's excellent advice. And I hope that anybody who may have a small claims matter heeds it, because it's the same thing that they teach lawyers: is anything you can do to make a judge's life easier for them, it only benefits your case. And so that's excellent advice. Another tip that I might give is, if you're curious about the small claims process, if you have a small claims case that's coming up and you don't know how it works, come sit in on a small claims docket before your case. You mentioned you have 2 a month, second and fourth Wednesday, is that right?
Yes.
Second and fourth Wednesday of the month. If you are going to have one or you're thinking about filing one, come in and see us. Sit through a small claims docket. See how it works. Our courts are always open in most cases. There are certain cases you can't see, but I always invite people, come on down. See how it actually works. You can learn a lot just from spending an hour sitting in court and watching how it actually works. And you'd be surprised how much more comfortable you will be if you go through that process, if you come in and do that homework up front.
We have had litigants do that. And there are times when they come on the initial appearance and I set it for a trial date 2 weeks out, and they stay and watch the whole docket to watch how the other trials are working. So some litigants will take that opportunity to watch and learn from other trials. And I do really appreciate that. And I've had attorneys come in and watch to see if they actually want to enter into a case or not, to see how the process is going to run and whether it's helpful for them to enter into a small claims case. So absolutely, our courtrooms are open and you're always invited to come and watch.
We can't promise that it'll be as exciting as Judge Judy or any of the shows you've seen on TV, but it is always very interesting. And I always get really good feedback from folks who come and hang out with us. Judge, I want to thank you so much for being here today to talk to me about the small claims process and small claims cases. It's always a part of the law that I was super fascinated by. It was always a really unique experience. And I want to thank you for sharing your experience with us today. And I think some really good, helpful tips for folks. Last question. I'm asking everybody this, and I have no idea why. It's just my thing. But I always ask everybody who I've had on the podcast, what's the best thing that you have seen lately? It can be a movie or a TV show or just a sunset, or what have you seen lately that you really, really like?
I love springtime, and it's beautiful. I love the flowers and everything, the smells, the sights, everything getting warmer, more daylight. The way I de-stress is if I've had a particularly hard docket or a particularly hard day, I always take a walk. I love getting outside and taking a walk. And right now, it cannot be more beautiful right now with the flowering trees and all of the flowers. So I guess that's the best thing that I've seen is the blooming of spring.
Well, Judge, thank you again so much for being here today. I appreciate you taking time out of your busy day. I know you just got out of a docket. You're probably going into another docket. We really appreciate you taking the time to hang out with us today. I also want to thank everybody for tuning in and listening to us today on whatever your platform of choice was. Thank you for being there. Don't forget, again, to like and subscribe our podcast and our feed so that you can get updates on our new podcasts and when new episodes drop so that you can have those available to you. Don't forget to also like and subscribe to the Missouri Supreme Court's Instagram and Facebook pages, where you can get all sorts of wonderful information about our court system and everything else that is going on with your Missouri courts. I want to give one last thank you to the judge for joining us today. And with nothing else to discuss, this podcast is adjourned. Thank you so much.